Well, we finally reached the point where we can talk specifically about how to complete the most frequent notary act, and that is the acknowledgement. First of all, we want to talk about what an acknowledgement really is, what it means, and why it's so important. Before we begin to talk specifically about completing acknowledgements, I want to remind you that you must first examine the document for completeness. As we've said before, a notary may not take an acknowledgement on a document that is blank or incomplete. However, the notary may ignore those areas that are to be completed a little later on, such as information that's going to be placed in the document by a county clerk or a recorder, or for additional signers whose signatures aren't being notarized by the notary public at the moment. Secondly, the identity of the signer must be confirmed by using the methods we covered in the previous sections under identification. Finally, be sure to enter all the information into the notary journal as we described in the previous section under journal entries. Now we're ready to complete the acknowledgement portion. An acknowledgement simply means that the document signer has acknowledged to the notary that he or she signed the document and that the notary properly identified that signer. When the notary completes an acknowledgement, the notary is certifying, and under penalty of perjury, 3 important facts about that signing event. First, the signer personally appeared before the notary public on the date indicated and in the county indicated in the county section noted as the venue portion of the acknowledgement. That the identity of the signer was based on satisfactory evidence, and that the signer acknowledged signing the document and did so in his or her own authorized capacity. Now, the process for completing an acknowledgement is always the same. First, examine the document to be sure it's complete and it doesn't have any blank or incomplete spaces that needed to be completed first. Remember that you'll have to be presented with the entire document in order to ensure this examination. Second, confirm the identity of the signer based on satisfactory evidence. Use the identification procedures we've already discussed. When a signature requires an acknowledgement, the signer may have already signed that document before it's even brought to the notary for notarization. If the signer's already signed the document, you'll need to obtain an acknowledgement from that person that they've signed the document since you didn't physically see him or her sign. So how do you do this? Well, you just ask, is this your signature, or did you sign this document? If the document is not yet signed, then of course just ask the signer to execute the document at that time. So there are 2 ways for a signer to acknowledge his or her signature to the notary. First, the notary receives an affirmative response from the signer when they're asked about the signature that's already there. Or secondly, the notary watches the signer sign the document. Now, the other part of this is that when the document signer acknowledges their signature, that acknowledgement simultaneously indicates to the notary that they have the authorized capacity, or that is, the right or the title that is required by the document to sign that document. So, for example, if the document's supposed to be signed by a CEO or by a trustee, the person who signed the document represents with their signature that they have the authorized capacity, or that they hold that representative title. The notary in California is not permitted to verify that title. So, while a notary in another state may be required to see, say, articles of incorporation or something like that to verify that the signer is indeed the CEO, for example, in California, that is not the case. And, in fact, it's illegal for a notary to do so. It is the signer who acknowledges their signature and the authorized representative capacity to sign that document, and it is not the notary's responsibility or duty to verify that capacity. Following the signature acknowledgement, the notary should complete the notary journal and then complete the wording on the acknowledgement and use the notary seal to complete the notary process. This is the California Certificate of Acknowledgement, which is either pre-printed on the document or is added to the document using an acknowledgement stamp, for example, or a separate acknowledgement sheet. The document signer will need to sign the document, but the notary must ensure the completion of the acknowledgement portion. And of course, the notary must sign underneath the section that states, I certify, under penalty of perjury, under the laws of the state of California, that the foregoing paragraph is true and correct. The certificate of acknowledgement must be completely filled out and must include the notary's signature and the notary seal. It's always the notary's responsibility to ensure that the acknowledgement is the correct form and that it's filled out properly. The notary may never place a notary seal or signature on the acknowledgement before that wording is completed. I also want to remind you that the acknowledgement is signed under penalty of perjury, so never complete an acknowledgement for someone who is not physically present before you at the time of notarization, or for someone who cannot present satisfactory identification. Of course, a notary may notarize the signature on any document, whether or not that document originates in California. But California notary law is very specific when it comes to notary wording. Remember that when someone brings a document to a notary, the document will already have notary wording either pre-printed or attached to the document. If the notary wording is not already pre-printed or attached, or otherwise suggested by the wording of the document, then the notary must ask the client what's required to be done. If the notary act to be performed is an acknowledgement, the notary will already know that by the wording. The notary won't have to guess what's going to be required, and the notary is not permitted to tell the client what is required. If the client doesn't know, then the client must find out from the entity that originated the document or who's going to be receiving the document. Okay, now other states will have their own notary wording for acknowledgments, and many documents that have been created in California will have wording that's different from the wording we just saw. That's because notary law changes over time, and many documents created in the past here in this state still retain old and outdated wording. So this is the important rule about using different wording for acknowledgments. If the document is going to be used in California, the acknowledgment wording must be exactly word for word, without any differences, the same wording as we just saw. We'll look at the wording again so you'll know what to look for. Now, if the document is going to be used or recorded outside of California, we may complete and seal that state's wording, which is often, by the way, very different, but we'll need to read through that wording to ensure that it's not requiring a notary to certify the authorized capacity of a document signer, for example, or to do anything else that's going to be illegal for a California notary to do. If it does, then you will not be able to complete that acknowledgement, and you'll need to attach a California acknowledgement certificate. That's called a loose certificate, but you'll need to attach somehow a California acknowledgement to that document. By the way, don't use a paperclip for the attachment. You should always attach a loose acknowledgement certificate with a staple. Now, if a document is to be sent outside of the United States, then the acknowledgement wording must be California acknowledgement wording, and remember, it must be in English. The notary is not allowed to use an acknowledgement in another language, even if the translation is accurate California notary wording in that language. It must be in English. So you might be wondering what an acknowledgement from another state may look like, and how to determine if it contains wording that would be illegal for a notary in California to complete. Well, this is an example of a notary acknowledgement from another state, and this example requires a notary to verify or certify the authorized capacity of the document signer. Now, notice that this acknowledgement requires that the document signer has proved to the notary his or her authorized capacity. I've changed the text color of this section to red. This is an example of an acknowledgement that a notary in California may not complete, even if the document is going to be used out of state. Part of the notary's responsibility is to verify the identity of the document signer, not the title that the signer claims to hold. In this case, the notary would need to attach and complete a California acknowledgement, or if there's sufficient room, use an acknowledgement stamp. Be sure to use the notary seal only on the document with the correct acknowledgement wording in order to complete the notarization according to California notary laws. By the way, you can obtain the CD with lots of notary forms, and that includes an unlimited supply of acknowledgement forms. All right, well, let's take a look at California acknowledgement wording and how to fill out the acknowledgement. The first thing to look for on an acknowledgement that is taken in the state of California is this disclaimer statement. Now, this disclaimer was added January 1st of 2015, so don't be surprised if you don't see it on a lot of the acknowledgments that you do. Unfortunately, if it's not there, and if the document's going to stay in California or it's going to be sent to another country, you will need to add it. And there's a couple of ways to add it. First of all, obviously you could put a disclaimer stamp on it. If you have a disclaimer stamp. But secondly, if you don't have a disclaimer stamp, or if it's just simply there's no room, if it doesn't fit, then you can just add what's called a loose certificate or a loose acknowledgement that you can obtain if you have RCD, for example. You just print out acknowledgement forms. The disclaimer box, a couple of things about that. First of all, let's go through the disclaimer box so you see what it says. It says a notary public or other officer completing this certificate verifies only the identity of the individual who signed the document to which this certificate is attached, and not the truthfulness, accuracy, or the validity of that document. You see, a lot of times when the public looks at an acknowledgement, they might have the assumption that the notary is actually doing something which legalizes the document, which frankly is just not the case. All we're doing is verifying identity. Now, the other part about this disclaimer box is that if there is no disclaimer box on it, as we said, you need to add it above the venue, which is the state of and county of section in the acknowledgement. And by the way, the venue indicates where the acknowledgement was actually taken. So it's going to obviously always be in the state of California, since we're required to be located in the state of California to acknowledge someone's signature as a California notary public. And the county is whatever county you and that document signer appeared in. So that's called the venue. Another important part of the discussion with this disclaimer box is that the disclaimer box cannot be hand drawn in, it cannot be handwritten in, it must be in an enclosed box, and must be in a typeface font that is legible. So again, one of the things to look for on acknowledgments, if it's taken in the state of California and it's going to stay in California, going to a different country, is does it have this disclaimer box already on there? If it doesn't, you'll need to add it, or you'll need to use a different acknowledgement form. All right, the second thing I want to point out here is that William A. Jones and Mary B. Jones did not sign this this particular grant deed with a title, but they could have. Their title could have been, for example, trustee, or maybe it was a property granted from a corporation, and maybe they would have signed it as corporate officers. The point is, they could have signed it with a authorized capacity or with a title, but if they did, you would never include that authorized capacity or title in the acknowledgement wording itself. You only put the person's name who signed the document and who proved their identity to you. So that's an important point, because sometimes, again, escrow companies or title companies or maybe attorneys will have already filled out this acknowledgement form for you and will have included those titles in this section. If they are included, you're not going to be able to complete that acknowledgement. You'll need to add a separate acknowledgement form, or at the very minimum, you're going to want to cross off and initial that title. All right, let's take a look at the body of the acknowledgement. Who proved to me, on the basis of satisfactory evidence, to be the persons whose names are subscribed. Notice that the notary has indicated the correct plural forms here. Subscribed to the within instrument, and acknowledge to me that they executed the same in their authorized capacities, and that by their signatures on the instrument, the persons or the entity upon behalf of which the persons acted executed the instrument. I certify under penalty of perjury, under the laws of the state of California, that the foregoing paragraph is true and correct. Of course, the notary signs here, and then puts their notary seal next to the signature. By the way, that notary seal needs to go next to the signature, and if there is no room, you'll have no choice but to add a separate acknowledgement form. Because you're not allowed to put the notary seal on top of wording or on top of any names or any lines or anything like that. And you certainly can't just flip the page over and put it by itself on the back side. Be sure to notice that the notary signs the acknowledgement under penalty of perjury, and the penalties are very severe for falsifying the acknowledgement. Because a notary is signing the acknowledgement under penalty of perjury, misrepresenting anything, including dates, names, identifications, or venue, is considered forgery. If the document pertains to a deed of trust, The penalty may be even escalated from a misdemeanor to a felony. Never backdate or predate an acknowledgement, and never enter the name of someone who did not personally appear before you at the time of notarization.